to support parliamentarians to hold government to account, and we should be doing that with them by our side.
Thank you very much. That is the time. Beginning our third round, Mr. Cooper, you have the floor for 5 minutes.
Thank you very much, Mr. Chair. Ms. Hogan, you found in your report 186 cases of conflict, 96 cases where declarations of conflict were made, 90 cases where they were not by, in almost all cases, board members. Would you agree that in all of those cases where monies were funneled to companies of board members, and that was in the case of almost all of those conflicts, totaling nearly $319 million, that was in contravention of the Canada Foundation for Sustainable Development Technology Act?
Well, I would tell you that we found that the 90 cases that were not well managed didn't follow their own conflict of interest policies. I think what didn't follow the Sustainable Development Technology Act was how the member council dwindled down to 2, and those 2 members were able to appoint 5 board members. That is where the act was contravened. The rest was around not respecting the contribution agreement.
Well, I would just through you, Mr. Chair, Section 12 sub 2 of the Act says that directors are not to profit, that no director shall profit or gain any income or acquire any property from the foundation or its activities, and yet $319 million was funneled into the companies in which board members had an interest, and that would seem to me, on the face of reading the Act, to be a violation of the Act.
I think, Mr. Chair, the member highlights an area where we noted in our report that the conflict of interest policy established by the Board of Directors of the Foundation did not comply with its act. Absolutely, the act was clear that an individual should not personally benefit, yet their policies were just provided for a blackout period. They were much less restrictive on the board members than they were on the employees of the Foundation.
Precisely. So they had a conflict policy that was inadequate insofar as it didn't necessarily meet up with the law in terms of complying with the law.
With its, yes, you're correct in that instance. Yes.
Thank you for that. Mr. Kennedy, the Auditor General's report is a scathing indictment of, I said, the department that you help oversee as the Deputy Minister. Your department has a duty to oversee $1 billion taxpayers' dollars that was sent to SDTC. We now know that taxpayers were ripped off. Nearly $400 million out of $850 million that was spent by SDTC was improperly spent. $319 million in cases of conflicts of interest, $59 million in which there was non-compliance with contribution agreements. Canadian taxpayers deserve a refund, and they deserve a refund now. What instructions has the minister provided you to get taxpayers their money back?
I think, Mr. Chair, we have been working with the organization, partly through the Management Response and Action Plan, to look at all of the organizations that are receiving funding now and to, this is my layperson's language, but effectively kind of rescreen them and kind of put them, back through some sort of process to examine, whether or not there are problems, like whether or not some of the issues identified by the Auditor General, remain present. The organization's actually engaged a third party. They have a third-party audit firm that's helping with that. So we're effectively, to date, and this will be something that the new management team, the new board at SDTC
How much of the $400 million of taxpayers' money that was improperly spent is going to be recouped, and when?
I think, Mr. Chair, it is important to keep in mind what we're talking about here, because there are kind of multiple levels of issues that have been, surfaced by the various reviews and audits that have been undertaken. There are going to be cases where potentially funding was provided and it needs to be recovered. There are going to be other cases where organizations, private sector companies, in good faith, engage in a contractual relationship with SDTC, presuming that, that what they were doing was in accordance with the rules, and may find themselves in a situation where actually...
Well, sir, the Auditor General found that there was $6.2 million, just a small portion of the $400 million in projects that were canceled by STTC that your department had a responsibility to recover funds from, and your department didn't even do that.
I think, Mr. Chair, on the issue of recoveries, that's a separate issue. We will be taking action to offset funds owed in cases of recoveries. It is absolutely the case that where an organization has not, spent the money, or whether it's been spent improperly, there needs to be a recovery. That money should be returned to the Crown. I would agree entirely with the member on that point.
Thank you very much. Up next, Ms. Yip, you have the floor for 5 minutes, please.
Thank you, Chair. Thank you to the witnesses for coming and answering our questions. Mr. Kennedy, in the beginning, the department initiated 2 separate independent reviews and also invited the Auditor General to conduct an audit. Why the 2 separate independent reviews, and how are each of those 2 reviews different?
Mr. Chair, I should just make sure the record's clear. I wouldn't want to speak for the Auditor General, but the Auditor General made an independent decision to conduct an audit. It was not at our invitation. I just want to make sure that nobody thinks that, much as we enjoy working with the Auditor General, that it was somehow at our behest that this was done. The reason for these 2 reviews are as follows. Under the legal structure that, is SDTC, and the kind of legal responsibilities that it has and that the Crown has, it is very easy for us to ask and indeed to follow up with audit work with regard to the contribution agreement. So this is the kind of contract we have with SDTC, which legally is this arm's length. It's not a government organization. It's a private organization at arm's length. And so the Raymond Chabot report looked at all of those issues related to, were they following the contribution agreement? Were they applying conflict of interest? Were they doing the sorts of things that frankly would be required by virtue of the contribution agreement? The Raymond Chabot report also made some observations about human resources, but you will note that in our management response and action plan, the character of what we have to say about HR is different than the other elements. And the reason for that is the human resources is actually legally the responsibility of the organization. It's legally the responsibility of the board. The Crown actually has no legal, these are not Crown employees. These are private sector employees working for a foundation. So we actually had to get agreement from the SDTC board to waive their rights, to allow the Attorney General to hire an agent to go in and do a review of HR. So obviously, given all of the allegations and given the pressure, the board was very cooperative, and they were certainly eager to allow the government to go in, but that was a separate process because unlike with the contribution agreement where we have full legal rights to kind of march in there and look around and demand documents, on the HR front, actually for the Crown to have taken action without the consent of the board and without sort of having all of its legal bases covered, that would have been actually ultra vires. It would have, I'm not a lawyer, but there's no legal grounds for the government to do that. And in fact, could attract quite a bit of liability and from employees and managers and others. And so we needed the board's assent to do that. And that was a separate process run by McCarthy Tétrault on behalf of the Attorney General.
I'm curious to find out what is happening for the funding for the companies with SDTC. We know that a lot of the companies were affected by the funding freeze. Is there a plan for resuming funding for these affected companies?
Thank you for the question. Mr. Chair, I will note when the Minister made his announcement in response to the Auditor General's findings, he did note that the plan is to get funding flowing again very quickly out to the clean tech ecosystem. Minister Champagne has been on record indicating his profound concern that clean tech companies have been caught in the crossfire as a result of this issue. That is a top priority for the new board that has been asked to take on responsibilities. So in effect, there are kind of 2 main responsibilities of the new board. One is get funding flowing again, but with all of the appropriate controls in place. And I said, as the continued holder of the contribution agreement, until such time as the NRC takes over, we will be applying all the enhanced controls in the management response and action plan. So effectively, until there's a new structure, the old structure prevails, and there's a new board that's been given very explicit instructions to, up their game on oversight, and the department has significantly upped its oversight of the organization. Ultimately, this will be transferred to the NRC, and then it will be the NRC's job to be administering the funding. But in the short term, we do want to get funding restarted, but with a much greater level of probity and accountability, as per the recommendations of Ms. Hogan and the various reviews that have been done.
So the CIC, which is the new, corporation that combines CDTC and NRC's IRAP, is going to be established by 2026 to 27. That's a long time away.
So, Mr. Chair, what I would say is there's two things happening here, and I think it's important to distinguish the two. So one is an immediate plan to effectively move the programming, the staff, who are all being invited to join the National Research Council, and the programming would be moved to the NRC. The plan is for that to happen as quickly as is practical later this year, for example. In the longer run, and the government has noted this, in the longer run, the plan is for the Industrial Research Assistance Program to form part of a new Crown Corporation that will actually have additional resources to support innovative activities in the economy. So that's a future step several years away. If or when ultimately the IRAP program moves over, that it is envisaged that this programming would move over as well. The fact that IRAP was to be joining the new Canada Innovation Corporation is a matter of public record. It was discussed in previous budgets. Because SDTC's programming would be joining IRAP, ultimately would move to this new home, but that is still several years away.
I'm afraid that's your time, Ms. Yip. Excuse me. We went generously over. Madame Secrétaire de Gagné pour 2 minutes 30 secondes, s'il vous plaît.
Ms. Sinclair de Gagné for 2.5 minutes. Thank you, Mr. Chairman. I just want to be sure I understand this correctly. I understand what you want to do is that SDTC one day will be managed by industry. Well, in the final analysis, yes. Immediately, it will be the NRC and later a new agency. Given that it's a Crown Corporation and these can also operate at some arm's length from a department, they don't have the same standards of accountability as departments. How can you make sure, if it's not a Crown Corporation, that these funds will be adequately managed? Because you're describing a scenario where we'll end up with the exact same problem. No, Mr. Chairman, I want to note that the plan, first of all, is to transfer things to the NRC. There's a few years left before it's transferred to a new innovation agency. When I noted in my introductory remarks at the beginning of this meeting, the STDC is even further than a Crown Corporation. There's a whole framework of rules and structures that exist for Crown Corporations that does not exist for SDDC right now. There might be a debate about what the best vehicle is, but a Crown Corporation has a great deal more transparency, far more rules that apply to its operation than the SDDC, but less than a department. For example, we can't find out where Crown Corporation money goes, and that's a problem. Increasingly, the government calls on Crown Corporations to do its work, literally, knowing that the standards for accountability and transparency of Crown Corporations are lesser than those of departments, and that's a problem. So, if the government thinks that it can create or recreate a fund or manage funds to help companies, they should do it through its own departments and not through Crown Corporations that don't have the same duties and responsibilities and need for transparency. That what you've just announced is a problem to my mind. If you have no comment, that's fine. I guess you're in agreement. Your time is up.
Or
No, Mr. Chair, I think I accept the concerns that the member has raised.
Thank you very much.
I don't have a response.
Sriva, turning now to Mr. Desjardins, you have the floor for 2.5 minutes, please.
Thank you very much, Mr. Chair. I do want to turn now to one of the findings in the Auditor General's Report 6.31. Quote, we found that through the Foundation's milestone management, the Foundation terminated 37 project funding agreements that had been approved during our audit period. It determined that $6.2 million needed to be recovered from 12 ultimate recipients because they did not demonstrate that funds were used for eligible project costs. To the Auditor General, do you want to highlight any additional information to that finding before I turn my questioning over to the Deputy Minister?
I think the only thing I would add is that we also found that the foundation had not informed ISED of that, so that they could take the appropriate action. That being said, ISED never really inquired about a canceled project, so I think there's a two-way accountability there.
I see. Now, to the Deputy Minister, to that fact that ISED never inquired, why not?
I think, Mr. Chair, as I noted at the outset of my remarks, we accept the Auditor General's findings that there needs to be enhanced oversight from the department. There was a variety of activities taken, reviewing of minutes, regular evaluations, attendance at meetings.
Just on that point, you say regular evaluations, but there were several times, and in the audit particularly, it spoke about the fact that departmental plans that are required under the Act simply didn't have the satisfactory information that would make your decision-making at ISED more accountable. It seems to me like either there's a situation of willful ignorance to the fact that there is a lack of true accountability because they're supplying annual reports that really have no information, ultimately leading to the charge of guilt that you just, by your own admission, relying on minutes. That showed to me that the level of information the ministry was getting was not sufficient. Correct?
I think, Mr. Chair, it's fair to say that the level of information that was flowing into the department was not sufficient. I mean, I think we certainly acknowledge that.
But why not ask then? Why not ask SDTC to provide more information?
Well, I think, Mr. Chair, very, very briefly, I think, as I tried to say at the beginning, for example, if ISED is administering a program, then we are directly responsible. And as a Deputy Minister, I want to know about where every nickel is going, and when there are problems...
But why didn't you then?
Well, because I think, Mr. Chair, the point here is that this is an organization that's actually at quite some distance from the government.
So it's not your problem?
No, Mr. Chair, I'm not saying that at all, but I'm saying many of the day-to-day functions that we might otherwise be directly involved in are actually being run by a third party at some distance from us. And the lesson, I think, which we agree with the Auditor General and we agree with the findings of the reports, the lesson is we can't be relying even on a well-regarded board to be always following its own processes and procedures and to be fully transparent with us when they find problems. We actually have to be doing more checking.
Are you going to get the money back?
Thank you. That is the time. I'm sure we'll come back to that. Mr. Perkins, you have the floor for 5 minutes, please.
Is he going to get the money back?
You'll have another round, Mr. Desjardins. Mr. Perkins, you have 5 minutes.
Thank you, Mr. Chair. I guess Mr. Desjardins' question, I'll just give you a brief second. Are we going to get the money back?
I think as regards the question of recoveries, that is an area we think is a priority. We think there needs to be action taken to offset those funds to STTC, who should be taking action to recover those
right,
monies.
It wasn't a priority in the past. So I'd like to come back to this relationship with the Assistant Deputy Minister that's been in the meetings. Auditor General, your report on page 22, I take it you must have spoken with a number of the directors about the relationship, because essentially on the top of the page on page 23 you say that when these votes of conflict were going on, either declared or not declared, since the Assistant Deputy Minister did not raise any concerns, board members assumed that the department was okay. That's essentially, if I'm fair, a summary, that there was an implicit agreement in the ambiguity or the silence of the department who was in every meeting.
We definitely spoke with many past and current board members and even the assistant to deputy minister, and there was confusion around what the role was. That was very clear, but yes, some of the board members voiced to us that it was an implicit agreement in their mind that nothing had been raised by...
Well, I don't think he was there just to eat the chicken fingers. I presume he was there to actually be a two-way conduit for both what departmental policy is to make sure they're following the contribution agreements and to report back anything that the assistant deputy. I've served on a number of boards. I would expect, including one Crown board, I would expect that the department, the deputy and the minister would be informed. In fact, I know in the case of the Crown I served on, the minister was very much aware of what went on at every board meeting.
Well, I think this is exactly why, Mr. Chair, we made a recommendation that this needs to be clarified and strengthened, and I personally spoke with Mr. Kennedy about this situation as we were closing off the audit.
So it's pretty clear in the Conflict of Interest Act, and the Conflict of Interest Act, which says, for public office holders, which says that no public office holder should make a decision or participate in making a decision related to the exercise of an official power. And when almost half of the money going out the door is conflicted amounts to government-appointed board members, that is not sort of one person leaving the room and it's an exception. It's actually the rule. So they're all working in getting conflicts, and it's a culture that causes a problem. So, Mr. Kennedy, were you aware that the previous person that was on there, ADM Noseworthy, had asked a previous chair, while he was serving as an observer on the board, had asked the previous serving chair for a job?
Mr. Chair, I'm not aware of these allegations. I'm sorry, I'm not in a position to comment on them.
If your ADM was asking a chair for a job while supposedly observing any wrongdoing, do you think that would compromise their ability or willingness to report wrongdoing in the board?
Mr. Chair, I would just say I am not, this is the first I'm hearing this allegation. I don't feel comfortable responding to hypotheticals, especially not about a former employee, but I am not aware of this allegation. It's the first time I'm hearing of it.
Okay, but it is not appropriate for a government official serving on a Crown Corporation board as an observer to ask that board chair for a job.
Well, Mr. Chair, I would say there are very clear rules that apply to designated public office holders about how they are to comport themselves with regard to future offers of employment, and I'd be happy to, well, actually, members would be well aware of those. They're a matter of public knowledge, so okay. I would just point to those.
If I got one last question back to the Auditor General.
Mr. Perkins.
Pardon me? Thank you. I'm very confused where, from a governance perspective, your report seems to imply that if you declare a conflict because they followed their rules, that somehow that's not an issue, when it's clearly an issue with regard to the SDTC Act, which says no director shall profit or gain from any income or acquire any property from the foundation or its activities. And so when you have almost half the transactions, almost half the money going to board members in companies they have a financial interest in, it doesn't really matter, does it, what the conflict interest of the policy of the board is? What matters is the act and breaking the act of Parliament.
So I think there's a lot going on here because there is also the Sustainable Development Technology Act that requires that the board members have experience and be involved that some of them have experience and be involved in the sector. I think that inherently, as Mr. Kennedy pointed out before, will create conflicts of interest, which is why a really rigorous process is needed. I would expect that it's more than declaring a conflict of interest. It's declaring and recusing yourself from any votes and decisions. But I agree with the member, Mr. Chair, that the Act also clearly states that no member should have personally benefited, and it is a concern, which is why we flagged it in our report about failures that the board had in respecting its enabling legislation.
Thank you very much. Up next, Ms. Bradford, you have the floor for 5 minutes, please.
Thank you, Mr. Chair, and thank you to the witnesses today. This is directed to you, Ms. Hogan. In paragraph 6.24, you write that estimates of environmental benefits by projects were unreasonably high. Can you explain what you meant by this and what made them unreasonably high?
Well, I might ask Mathieu if he wants to join in here. I think we were raising a few things, is that there was no target set in what should be a reasonable target when it comes to determining the environmental benefits. We found that most of the applications quantified them, but they were very high, and in order to, part of our conclusion was based on the fact that we looked at completed projects, and in 12 out of the 18 completed projects, the estimates, the actually received benefits were 50% lower than what had been estimated. So while I know that an estimate is difficult in this area, that was a lot of projects to have not achieved its benefits. Nothing else to add from Mathieu.
Thank you. So in 6.44, you note that the same law firm that the Foundation's external general counsel worked for was hand-selected to produce a report on financial mismanagement and human resource practices at the Foundation. And you note that this could give the appearance that the investigation was not independent, unquote. However, this also appears like a selection based on previous work and trustworthiness. So in your view, how can foundations and arm's-length corporations better prepare for perceived conflicts of interest? And how can board members get a better understanding of what a perceived conflict of interest may actually be?
So that entire paragraph in our report actually highlights some conflicts of interest that might be real or perceived that were really not addressed by the conflict of interest policies in the Foundation. There are so many best practices out there that that boards can use to help establish what their conflict of interest policies look like. There's the Federal Values and Ethics. There is the Conflict of Interest Act. OECD has guidelines in the public service when it comes to conflicts of interest. There is other countries, my counterpart, the ANAO, actually has a guide on conflict of interest. I think there's lots of areas that best practices can be sought, but this is about ensuring that from a public perception, that an individual never appears to have put themselves in a position where they may benefit from public funds. And when you're involved with public funds or in the public service, you need to be held to a higher set of standards. And I'm going to turn to Andrew because I know this is an area that he's really passionate about, and I'm sure he probably has something he might like to add.
Just one thing to add to your question. The individual that we're talking about there, the general counsel, is also one of the 2 members that is remaining on the member council.
Thank you. And Mr. Kennedy, getting back to the Constitution, how the Board of Directors were arrived at, there were 8 of the Board of Directors who were appointed by the Governor in Council. Can you explain the process and the backgrounds of those who were appointed in this way?
Thanks, Mr. Chair. For GIC appointees, there is a standard process that the government follows. Typically, there's a poster or, a kind of advertisement that's made about an opening. People are invited to apply. There's a deadline set. There is a screening process that is typically managed by the Privy Council Office in partnership with the lead department. There is, through that screening, there's a kind of more limited set of candidates that are identified. There is then an interview process. Sometimes, and I apologize, I don't know what happened with these individuals, but having been involved in a lot of these processes in the past in other contexts, there are sometimes psychometric assessments. There's usually reference checks and so on. And then at the end of this process, the government decides, those who make it through the screen, which ones will be selected, and then those are approved by the cabinet through the GIC process. So there's a very elaborate process. Those include conflict of interest checks, security checks, typically, et cetera.
So were any of the 7 members who were elected by the board directly involved with these conflict of interest cases?
I would have to look at my notes to determine sort of who was implicated and not, but as noted, there is a majority that are appointed by the members of the organization, which is at arm's length from the government, and then there are GIC appointees. I don't know whether the Auditor General might want to speak to that. Sorry.
I can actually probably provide some information there. In the 90 cases, in the 88 cases that involved directors, there were 10 directors. Out of the 10, 7 were Governor and Council appointees.
Thank you very much. That is the time. Mr. Cooper, this begins our 4th and final round. You have the floor for 5 minutes, please.
Thank you, Mr. Chair. Mr. Kennedy, you stated that your department, I said, acted swiftly upon learning of mismanagement at SDTC when it received information from the whistleblower on February 16th, 2023. With the greatest of respect, I say that simply is not sufficient. Your department was responsible for overseeing compliance with the contribution agreements and to ensure that there were not conflicts of interest. And we now know that 400 million taxpayers' dollars improperly went out the door, much of which went to pad the pockets of Liberal insiders who sat on the Green Slush Fund board. So do you accept any responsibility as Deputy Minister for that?
I think, Mr. Chair, I was on record at the beginning of the meeting of agreeing with the findings of the Auditor General's review that...
Do you accept responsibility, yes or no?
I think, Mr. Chair, as I said at the beginning of the meeting, we agree with the Auditor General's report of the necessity of ISA doing additional oversight of the organization, and we have a fairly detailed plan to...
So you don't accept any responsibility, that's what you're saying. So maybe you can help Canadian taxpayers who've been ripped off understand how it is possible that your department never received or requested conflict of interest records from the Green Slush Fund.
I think, Mr. Chair, as I noted at the beginning, we agree with the Auditor General's finding that there needs to be additional oversight done by the department.
No kidding. But how is it possible that your department didn't even ask for any receipts? And maybe while we're at it, maybe you can explain why your department failed to conduct even a single audit to determine SDTC's compliance with the contribution agreements with your department.
Well, Mr. Chair, as I noted at the beginning in my comments, this is an organization that has an unusual status. It isn't even normal.
The Auditor General found, sir, it's very clear, 6.67 of the Auditor General's report sets out the responsibilities that your department has, that I referenced. So the notion that it's arm's length doesn't mean that your department has no responsibility. 1 billion taxpayers' dollars went to SDTC. So don't tell me that because it's arm's length, that somehow you can gives your department the basis to say, well, it wasn't our fault when you never requested conflict of interest records, when you didn't conduct a single audit, when your department failed to request any information from SDTC about terminated funding agreements. Quite frankly, sir, I would actually ask this question. Can you point to anything your department did right?
I think, Mr. Chair, the Auditor General's report notes a range of activities we did as part of our oversight. Clearly, those were not sufficient to catch the problems at the board level. But I would note that, this is not an organization that even typically would be subject to audit by the Auditor General, unlike, say, my organization that is regularly audited or the NRC that is regularly audited. This is a private sector organization that is far removed from the government. It's not government property. The principal responsibility for enforcing these rules was with the board. Our oversight was not sufficient to catch the fact that the board wasn't fulfilling its duties.
You had an assistant deputy minister sitting in on the meetings, observing conflict after conflict after conflict, and your assistant deputy minister did nothing, and your department did nothing, and there was no direction from the minister that your department do anything. And it is a complete and utter breakdown from the standpoint of a proper oversight, and Canadian taxpayers are out $400 million as a consequence. I want to ask you about the $38 million in unlawful COVID payments that the board approved, millions of which went into their own companies. They didn't recuse themselves. The chair even moved the two motions in which her company was enriched by several $100,000 as a result of those COVID relief payments. The Auditor General's report is very clear that your department was aware at the time that the board approved those payments. Can you explain why your department turned a blind eye to what amounted to a black and white violation of the contribution agreement with respect to $38 million that went out the door?
I think, Mr. Chair, I've already spoken to this issue before. I would simply note that, the reason why this organization is being moved to the NRC
You knew about it. You knew about it.
Is because it's very...
You knew about it, right, sir? You knew about the $38 million that went out the door unlawfully?
I think, Mr. Chair, I feel like I've already spoken to this issue.
I'm asking you.
I'm happy to provide some elaboration.
Mr. Cooper, your time just ended, so why don't I'll give Mr. Kennedy time to respond. You have the floor, sir.
I would simply note, and I think there's been extensive testimony today, that the very design of this organization, which by statute has to have members on the board with deep experience in the clean tech industry, the fact that it is arm's length and is not subject to a lot of the usual checks and balances, that called for additional oversight and scrutiny. We agree.
It's like you're washing your hands clean of any accountability. Canadian taxpayers deserve so much better.
We will move on now. Ms. Shanahan, you have the floor for 5 minutes, please.
Thank you very much, Chair. And actually, I'd like to address the design of this organization because, I mean, obviously there's reasoning behind that. We're in the tech sector. That's not normally an expertise of public servants to be choosing, you know, what we call winners and losers when it comes to identifying technology that's going to be the technology of the future. So I'm just trying to understand, Mr. Kennedy, is this common practice to have this kind of organizational structure? And I guess I said would be a place that we would see government working with the private sector.
I have to say, Mr. Chair, this is very unusual in the stable of organizations we would support. We would either be working directly with a Crown agency, such as the Space Agency or Statistics Canada. There are a number of these in our portfolio. Or we would be engaging with a third party, but as an agent to deliver against a very specific set of criteria in terms of what we're asking them to do. This is a very different circumstance. This is an independent organization. They are flowed money through our contribution agreement, but many of the choices about how they structure their programming, about how they govern themselves, their various processes, those are all with the board and the management team to make those decisions. That doesn't remove the obligation on ISED to be carefully monitoring and overseeing the contribution agreement, but the design is such that a lot of the kind of, you know, day-to-day about how the business is done is entirely at, you know, the responsibility of the board. And the lesson, I think, here is that, you know, even with a board of private sector experts, you know, brought in to provide oversight, that the kinds of activities we undertook to, you know, to kind of attempt to ensure that the contribution agreement was being followed, you know, reviewing minutes, you know, doing regular evaluations, you know, even sitting in on meetings wasn't sufficient to identify these problems and correct them. So an analogy I might give would be, if you're a large bank, private sector organization, you have a board. The board is composed of people who are, you know, experts and well-regarded. They actually have the responsibility for the oversight of the bank. But when it comes to things like finances or certain kinds of issues like, I don't know, cybersecurity, you have a third party like an accounting firm that actually comes in and audits the books and independently verifies that the bank is doing what it's supposed to do. We did not have the kinds of control frameworks that might have actually caught these kinds of issues. There was too much reliance on what I might call, you know, more informal processes like reviewing the minutes. The Auditor General's noted the minutes often, you know, occasionally didn't include the kinds of information you would need. So even if you're reviewing the minutes, if the minutes aren't complete, you're not going to catch the issues. What I can assure the committee of, in terms of the fallout from this episode, is that under the action plan, we're replacing these kind of measures with much more formal control processes, requiring sign-off by a senior official, requiring regular auditing, requiring third-party validation. So the checking of the homework of the board is going to be much, much more diligent and much, much more rigorous. I think the observation I would make would be, if there's a lesson here, it's that, you know, even an organization with a well-regarded board, that there needs to be additional infrastructure to be, you know, closely verifying whether or not, you know, a board is following its own rules.
Well, thank you very much for that testimony, because I think that is part of the work of this committee and the good work of the Auditor General's office in addressing deficiencies and gaps, identifying them and going forward. So is there anything in your action plan, because I see by your letter you have one, that you would prioritize going forward?
Mr. Chair, what I would say is that we believe all of the measures in the action plan are important. The action plan touches on issues around eligibility. The Auditor General's noted that was an issue. Conflict of interest, very serious issue. So the various dimensions of The audit findings are captured by the action plan, and we have been diligently pursuing all of them. And at this point, all of those elements of the action plan are fully implemented.
Well, thank you very much. And if I have a moment, I just wanted to ask the same question to the Auditor General. What would you consider a priority out of the recommendations? And I know there's a number of recommendations, quite detailed, but the overall priority.
I'm assuming it's not a good answer to say all of the recommendations, but I think addressing immediately the conflicts of interest, and that's why I was happy to see that greater accountability would take place as this moves under the umbrella of the public service. For sure is an important one, but I do think it's important that the government do the extra work needed to identify if there are other projects that were ineligible, and then either taking measures to recover those funds or at least being transparent with organizations about whether or not they will or won't, right? I think I've always been on record that if an individual receives or a corporation receives funding from the public service or the government that they shouldn't receive, it should be recovered, or the government should be clear with them what they're going to do.
Thank you very much. Suivant, c'est Madame Sinclair. Tanguy encore une fois pour 2 minutes 30 secondes.
Yes, thank you. I'd like to go ahead with the same line of questioning, but I'll turn to you, Mr. Kennedy. Could you transmit to the committee when this is done? When you've taken into account the recommendations of the Auditor General that she's just issued? For example, having a general overview of all the projects, their eligibility, and when you have that, transmit it to the committee? Yes, Mr. Chairman, I'll be pleased to provide the committee with that information. Excellent. And all the other information that the Auditor General just mentioned that are necessary, particularly when the funds come from taxpayers. The National Research Fund will, as we await the creation of the Crown Corporation, will have the funds necessary. The employees followed. All the employees followed. That's the plan to offer those employees. About 70 employees. I don't know the exact number, but about between 60 and 70 anyway. Okay, so they will go to the National Research Council. Now, could you also send to the committee, once that's done, the recommendations that are in the report, not just the ones just mentioned, but those in her report that were acted upon by the National Research Council since the original organization no longer exists? We can provide an integral response to the committee. When it comes to the chain of command, can you identify, or more likely, have you identified one or more people specifically who will make that adequate follow-up when it comes to eligibility projects, conflict of interest? Have you identified who in your department will do that work? Well, Mr. Chairman, I want to note that responsibility for managing the department rests with me. I'm prepared to answer questions, but for the NRC, it's Mitch Davies. We are responsible with our teams. Well, Mr. Davies will therefore ensure himself that the projects that are currently funded are eligible. Discussions on those questions are underway. I don't know whether we're still in the same space in 8 months or a year, but that is a concern for us. We want to look at the recommendations of the Auditor General, look at the projects, and see what the next step is. What about projects that shouldn't have been funded? Will you tell us when that money is found and recovered? I don't know if members are aware, but I've already written to the committee promising that we will come back with an action plan and with transparency on our actions. Thank you very much.
Jill, you have the floor for 2.5 minutes.
Thank you very much, Mr. Chair. And I do want to return now to the serious issue of recovery of taxpayer money. You did mention several times, Mr. Kennedy, that as a matter of fact, there would be a process that would be undertaken to actually deliver some of this money back to the hands of taxpayers. And so as a matter of doing that, is there a plan in place, or has there been a plan developed to actually see to it that that money will be recovered in a timely fashion?
Mr. Chair, we're working on that now with the new board. The new board, as members may appreciate, was only recently appointed. But the issue of recoveries, I think, is pretty clear. Monies that were paid out to ineligible activities should be recovered. My organization does that. When we discover that there's money that goes to an eligible activity, we offset that with future payments if it was an honest mistake, or we recover the money because it wasn't supposed to be paid out. We would expect SDTC to do the same. We will be taking measures with SDTC to make sure that those steps are taken.
Now, what level of accountability do you take as Deputy Minister of this department for the recovery of this fund?
Well, I think, Mr. Chair, there are two things here. One of them is our agreement with SDTC. That is the principal instrument we use. So we would have to look at what are the kind of methods or what are the steps we would be able to take through the contribution agreement to kind of help to affect that. The actual recoveries have to be done by SDTC. So that's the legal point, Mr. Chair, but just for the member's question, the legal...
No, I understand.
Okay. Sorry.
And related to the contribution agreement, so you're saying that you can take all matters that you have, at least I hope you would, take all powers you have under the contribution agreement to actually recover funds of ineligible expenses, correct? Is that what you're saying?
Yes, Mr. Chair, that's right. So, for example, if there's...
So why wouldn't you, at the onset of this work, knowing that there was already instances of conflict of interest stemming back to an internal audit as early as 2018, undertake the work of making sure that your contribution agreements actually had that kind of power to begin with? Absent of my questions on transparency, why doesn't it have basic level of accountability when it comes to even recovering projects for ineligible funds? Because it sounds like you're describing a limitation.
No, Mr. Chair, maybe just to be clear, what I'm saying is we agree with the importance of recovery of funds. We'll have to, any measure we take has to be through the ambit of the contribution agreement. It was just simply to note, as I said at the outset, we're not directly administering these funds. This is not like, this money is...
Can you table, just because of time, could you table with us your plan to have this money recovered to our committee, please?
I think, Mr. Chair, as I responded in response to the last member's question, we will be happy to come back with a fuller picture of what we are doing in response to the Auditor General's
A detailed plan
findings.
in writing, please?
I think, Mr. Chair, as we normally do, we have a written follow-up plan to the Public Accounts Committee. We'll be very happy to do that.
Well, I'm sorry I have to ask basic questions, but there's been basic level of misconduct here, and I would appreciate you understanding the gravity of the situation and our need for basic documents.
So, Mr. Desjardins, I think, if I'm going to read this a little bit, I think Mr. Kennedy is telegraphing that they're in the process, I think, of sorting this out, and he's prepared to come back to us and update us on that progress. Perhaps we'll do that after the summer recess. So I'm going to let his answer stand. I realize you're trying to get an answer now, but I just don't think they're in a position to provide it yet, but I'm hoping that will come. I'm going to turn now...
by the summer, then.
We will. The committee will pick it up again, and we might well have Mr. Kennedy back. Mr. Perkins, you have the floor for 5 minutes.
Thank you, Mr. Chair. Mr. Kennedy, last week, the former Liberal Minister of Industry, Navdeep Bains, was in Industry Committee testifying on this issue, and he is the minister he began saying his only responsibility for the Green Slush Fund was actually appointing the directors. So when I questioned him on his 5 appointments, Annette Vacherian as chair, Guy Ouimet, Andre Lise-Miteau, Stephen Kakucha, the former Liberal organizer in British Columbia, and the 5th one is a person who chaired their governance committee. I asked him if he was aware that all of those folks were basically shoveling money to their own companies, and he declared amnesia at even appointing them. And didn't remember anything. Very useless testimony. And then when I asked some of the staff, including a former PMO staffer who works at SDTC, or worked at SDTC that time, she also declared amnesia. So I guess that's the Canadian version of taking the 5th. So what I need to know is, why did Minister Champagne not fire any of these directors?
think, Mr. Chair, that's a question probably best put to the minister. I don't.
Well, you provide them the advice.
But I think it would be better if there's a question about why a minister didn't take a certain action
Did you provide them advice to fire these 5?
I think, Mr. Chair, as members will know, deputy ministers don't discuss their advice to ministers, in a public setting.
I hear that, more
Westminster.
taking the fifth. So I want to know then going forward, these 5 directors feather-bedded over 300, maybe almost as far as $400 million to companies they had interests in, financial interests in. I was able to find out through the internet on my own about 150 million of it. It's readily available in public sources. So I want to know going forward in your new world with this, 1, we will ensure that we try to get some of that back, and 2, that the fund under NRC control will not have business with the companies that these people have already taken a huge amount of money for abusing their public position for their own interest, that they will be banned. Because I don't buy, because there was no chair of this fund in its 20 years before Annette Verschaeren that had a conflict. So I don't buy that you can't find people to put on the board without a conflict. That's a failure. But I want to know going forward, will you ensure that they no longer get to skim taxpayer money any more from this fund when they've gotten almost $400 million already?
I think, Mr. Chair, I would say that we believe that the fundamental structure of this organization is contributed to these problems. The design of the statute is such that people are going to be on the board who are at high risk of conflict. I think the move to the NRC
They don't have to be on proper screening to have a conflict. That's total BS.
I'm simply noting that, Mr. Chair, that the move to the NRC is a major step towards eliminating what is a kind of ongoing
So as part of the condition of it moving to NRC, will you make sure, as the deputy, advising the minister that this fund, under its new governance rules, they will take direction from you on improving their conflict of interest, will not do business with these companies, so these directors and former directors, liberal hacks and cronies, cannot steal taxpayer money anymore?
I think, Mr. Chair, what I would say will be, there will have to be, and there will be, a kind of a consideration of all of the findings of the Auditor General's report, the Raymond Chabot report. Decisions will have to be made on what to do in cases where, as the Auditor General said, for example, money went out to an organization that would not, under the terms of the contribution agreement, normally be entitled to receive it. I will say I am in 100% agreement with the need for increased probity and for additional scrutiny. I do have to note, though, just in response to the member's question, at this point, we don't actually have any evidence of deliberate malfeasance, criminality, et cetera. So I think.
Look, I have to stop you there.
To say,
we have asked that it be turned over to the police. Yeah. That's true, the RCMP. But it's very clear from the evidence. At least $150 million is available on the website. We've had directors admit they sat in board meetings and voted their own money. We have to stop that, at least going forward. You can set the terms going forward that these companies and these individuals that have this interest cannot profit from the taxpayer in this way anymore.
Mr. Chair,
that has nothing to do with police charges.
Mr. Chair, I appreciate the member's question. My only point was to say that in order to respond to it, I think there's a measure of due diligence that's needed. In the case of recoveries, the money that was put out to ineligible activities, that's black and white. In the case of companies where there's a conflict, the kind of facts on the ground matter.
They broke the STTC Act and the Conflict of Interest Act.
But Mr. Chair, I would simply say that you have to look at each case individually. In the case, for example, of organizations that receive money but weren't necessarily compliant with the contribution agreement, the contractual arrangement between the company and STTC may be such that the company wasn't aware that STTC was coloring outside the lines. They may have entered in good faith into an agreement.
Coloring outside the lines.
Thank you very much.
Well,
thank you very much. Our last member, Mr. Weiler, joining us online for 5 minutes, please.
Thank you, Chair. And I do want to ask another question of Mr. Kennedy. And I have a number of clean tech companies in my riding that have worked with SDTC in the past. Some that are actually we're currently in the process of seeking funding from SDTC when the funding, of course, was frozen. This organization, of course, provides a critical service for clean tech companies in Canada, where we do have challenges with access to finance. And I was hoping you could just provide just a very clear statement to me and to this committee, just to outline what these companies and other companies across the country can expect with the timeline of what is going to happen with funding and the funding freeze, and when they may be able to expect to reopen those conversations so that those processes can continue.
Yes, Mr. Chair, I'm happy to answer that question. I just maybe very briefly, my point in the last question is we have to look at the facts of each case, because there are going to be cases where people acted in good faith, and the fact that there is a deviation does not constitute criminality or malfeasance. If we had found evidence of criminality and malfeasance, we would have acted. I think there have been some very incendiary allegations made. We have to look, as officials, we have a duty to look at the facts and the evidence and make judgments on the basis of the actual facts on the ground. So it's going to take some time to be able to answer some of the questions that have been raised. That was my only point earlier. With regard to restoration of clean tech funding, this is a major priority. There have been many evaluations over the life of SDTC going back to its foundation that have, notwithstanding the serious issues that have been uncovered through these audits and reviews, that have suggested that this organization has played a pretty important role in the development of a clean tech ecosystem that is regarded not just by the government. There are many independent reviews, by international organizations, business periodicals and others that actually note that Canada is a leader in clean tech startups. We have an ecosystem of clean tech companies in this country that is actually envied by many other jurisdictions, and SDTC has played a role in that. So there's a very strong interest in not losing, the ecosystem and having permanent damage to many SMEs and others that are working, whether it's in the oil sands or whether it's in, clean water or whether it's in many, many other sectors of the economy all across the country, that we don't sort of lose the ecosystem by virtue of the crisis that's unfolded with SDTC. So there's a very strong interest in not kind of, having the business sector that has been assisted by this funding be sort of, harmed in the long run because of the problems that have been identified. This is the reason for the Minister's action plan and the efforts to transfer the funding to the NRC, is to kind of put this back on a sound footing, have an oversight mechanisms that are much stronger, give people confidence that the kinds of diligence that you would want to see are, is in place. Largely driven by these concerns about the many companies. And there was testimony, my understanding, before Parliament by members of the clean tech community who have actually spoken about the damage that's been done by the arresting of the funding. So that is something that's we're very alive to, I guess I would say.
Points very well taken, Mr. Kennedy, but just in terms of timelines about when the resumption of funding might be able to take place, even if a ballpark of what you might be able to say for companies that are asking for such.
Well, I would say, Mr. Chair, that the funding resumption has already started. That there has been some recommencement of funding. As I noted, we had been working with SDTC as they put their management response action plan in place. We're now satisfied that all those measures are in place. They have been companies in their stable. They have been sort of putting through additional diligence to make sure that that we are satisfied and that everyone is satisfied that they meet criteria around eligibility, around conflict of interest, and actually SDTC has been assisted by a third-party audit firm in doing that. So there's already been some funding that's been going out to organizations, and that has only happened when there has been fairly extensive diligence to kind of demonstrate that the funding is not going out in a way that's problematic or or suffers from the issues that the AG found in her review.
Thank you very much. And just lastly, you mentioned it very briefly earlier, but the transition plan for employees from SDTC.
So employees have been informed that it is the government's plan to offer them employment at the National Research Council, and that transition work will be overseen by the new board, in particular by Paul Booth as the board chair. The minister has asked Mr. Booth and the new directors to take this on. And I have had a meeting with the employees, with the new board chair, to explain that it is the government's plan to offer them roles in the NRC. We don't want to lose the expertise of the rank and file employees because of the events of the last year. That will be overseen by SDTC, working closely with the NRC.
Thank you.
Thank you.
Thank you very much. Just a point of clarification that from the analyst. Recommendation 6.29, which I'll note was one of the two priority recommendations as referenced by the auditor earlier. Now, and that's again 6.29, SDTC partially disagreed with the recommendation to reassess projects approved. They stated that, quote, written records did not fully capture the robust deliberations made, end quote. Now, today, ISED, through you, Deputy, stated that it would it would proceed to a review. Does ISED, therefore, agree with the recommendations made by made to SDTC by the Auditor General? You seem to imply that you supported it, whereas SDTC did not. Could you just clarify that, please?
Mr. Chair, I'm just reviewing the material here.
Sure. And again, it's recommendation 6.29.
Yes. Mr. Chair, just to clarify, this is language from SDTC, and so what I think SDTC are saying is they'll work in cooperation with us to reconfirm that active projects, so in other words, projects that are not historic and kind of in the past, that they will meet the goals, objectives, and eligibility criteria set in the contribution agreement. And we would say that that's, job number one. I mean, there's conflict of interest issues and so on, but clearly our very strong insistence will be that future projects fall within the four square walls of the contribution agreement, and that will be part of the oversight activities we undertake to ensure that. So I think that last paragraph is accurate. It's coming from the organization, but I would agree with that. We will be working closely with them to make sure that they follow the rules.
So just trying to, so SDTC partially disagreed. Do you reflect that disagreement? Do you share that disagreement? And again, asking for clarification because earlier you seemed to suggest a review would be done. I just want to know if you're in agreement with that partial disagreement of the auditor's recommendation.
I think, Mr. Chair, what I would say would be, I'm speaking for ISED.
Yeah.
And we have findings from the Auditor General and findings from RCGT that raise questions around things like eligibility. So I'm just using that as an example, but funds went out. So there's a question that is that members have put to the government, which is, what are you going to do about that? So we as an organization have to make determinations of what to do in these various circumstances. I've already testified today on recoveries. We see that as pretty cut and dried. We need to be taking action on recoveries. We will be looking at the other areas. We've committed, we'll come back to the committee to explain what we're doing in that space. But SDTC, and again, you have to appreciate, Mr. Chair, there's new management at SDTC since this report was drafted. So there'll be a new management team that may or may not, be in exactly the same place. But clearly, SDTC partially agreed with this recommendation. But they would have come to their own assessment of whether projects reviewed during the audit period met the terms or not. But that's also a judgment ISED makes. We have a contribution agreement. We will not necessarily in all cases come to the same